Good evening, everybody. Thanks for joining us. This is Melinda Nipfer from Special Education Advocacy Services of Luzerne. We are very grateful and thankful that tonight we have Landon Hodges, an attorney with, and is it Steinbacher? Is that how you pronounce
Yes,
it? Good
correct.
old Yurchak. Yurchak?
Yep.
I'm sorry. I'm terrible with a lot of names. Look at the accent that comes out of this mouth. But we're very lucky to have you here because you're going to be giving us a presentation on guardianship, ABLE, and so many other things that from our transition into adulthood. We've got a lot of kids that are transitioning into 18 plus range. And so we're really grateful and thankful that you're here, that you're going to be able to present for us and answer all of our questions. For everybody who's live, you'll be able to put your questions in the chat. And for anybody who's watching this afterwards, there is a um, Survey Monkey survey that if you want to fill that in, that you can actually ask questions and have a discussion with somebody from the firm. Now, this presentation is informational and does not constitute legal advice or establish attorney-client privilege. I'm going to edit that and bring that back up just so that we have that on there correctly, because I had does. There we go. Does not. Oh my goodness, it didn't save it. Oh, see, technology. Now I'm going to have a really
All
big
right.
problem with this. Does not. Where's my save? There we go. Now it's done. Does not constitute legal advice or establish an attorney-client relationship. So what we'll do, we'll save all our questions till the end. I know that there are plenty of questions. We got a lot through the email, and we have some parent ones that are already set up, ready to go. So Landon, thank you for joining us. I'm going to let everybody know that Landon is an attorney and partner at Steinbacher, Goodall and Yurchak, and he's licensed to practice law in Pennsylvania. Landon was born and raised in Mount Airy, North Carolina, and he graduated from Wake Forest University in 2014 with a Bachelor of Arts degree in political science with minors in philosophy and sociology. Upon graduating from Wake Forest, Landon attended law school at Elon University School of Law in Greensboro, North Carolina, and he graduated cum laude. Landon currently serves on the board of the North Central Pennsylvania Estate Planners Council, an organization that provides resources and education to estate planners of multiple disciplines, and the Road to Freedom Center for Independent Living of North Central Pennsylvania. And the Road to Freedom is an organization that empowers people with disabilities and provides resources and services to allow them to live as independent as possible. Landon actually joined Steinbacher, Goodall and Yurchak during his last semester of law school in January 2017 as a legal extern, and he has since obtained licensure to practice law and practices primarily in wealth protection planning, long-term care planning, tax planning, life care planning, and estate administration. In May 2021, Landon became a partner with the firm's acquisition of the law office of Leslie Weiselman in Wyalusing, Pennsylvania, and now practices in the firm's Wyalusing office and in its satellite location in Wystocks, PA, as well as in the Williamsport office. So you are all over the place, Landon. Landon currently resides in Jersey Shore, PA, with his wife, Emily. And in his free time, Landon enjoys traveling, socializing with friends, and reading. And I will not, because we're Pennsylvania here, put down which team you go for with football. But let's
Yes.
say it's not Penn State. So thank you and welcome, Landon. We appreciate you being here.
Well, thank you for having me. I'm glad to be here.
You have a mouthful of a bio, which is wonderful because we know that you know your stuff.
Well, let's hope so. But all right. Well, thank you for introducing me. And all right, are you ready for me to share my
I
screen?
am. So if you just want to share that, and then we'll pop that on and we'll go straight into.
Absolutely. All right. Okay. Can we see? Can everybody see this?
I can see it. That's not a problem. I'm just going to pick this off the bottom. So there you go.
All right. Well, thank you for that introduction. And again, thank you for having me. So we're going to switch to a drastically different accent because, as you mentioned in the bio, I'm from North Carolina. So my pronunciations might be a little bit strange to some of you, but yeah, what we're going to talk about today is legal concerns and transitioning to adulthood for those with disabilities and special needs. I get a lot of questions, and there's a lot of misconceptions out there. And just so you know that during my presentation today, I'm going to cover a lot of specifics in terms of benefits that are available and a lot of legal strategies that can be used to plan around things. So if you miss something at the end, there's going to be a lot of resources and links that we can share with you, and you'll be able to be provided with those afterwards. So if you feel like you've missed something, don't worry. We'll be able to circle back, and of course, I'll take questions at the end. All right, and I'm going to try to make this topic interesting because I know estate planning can get a little bit dry, but this stuff is important, and I get a lot of questions in this. So let's go ahead and dive right in then. All right, so let's start talking. Let's start generally with the tools that are used during this transition. So, of course, when somebody is under age 18, they're a minor under the law. So their parents are their natural guardians, or if they've been appointed a guardian throughout childhood, that person is their guardian, able to make all their decisions. But under Pennsylvania law, as soon as a person reaches age 18, they're considered to be an adult, and they're presumed to be able to have full agency over their own decisions, which is good. But that's, of course, that does not work for everybody. So there's a lot of tools in place, such as power of attorney, supported decision-making documents, guardianships, trust, able accounts, and multiple benefits available to help somebody live as independently as possible. You're going to notice throughout this that this area of law is wrought with all kinds of acronyms and everything. So one of the things I hope to accomplish today is to demystify some of it and at least show some of the differences between a lot of the terms you might hear. So the legal concerns, and it all starts with estate planning documents, because any good plan starts with good documents. And to the extent that a person's able to understand and sign legal documents, this is a lot of times the least restrictive option to ensure that a person has a person to be able to advocate on their behalf and make decisions if needed. But there are also financial concerns that we'll discuss that is very relevant to inheritance or leaving money to be able to support a person. So I'm going to try to cover all of it and without throwing too much at you at once. But again, I will certainly take questions as we go. So when I say estate planning documents, the most important document that can be in place for this would be somebody that's doing their estate planning in the second half of life, or any person that's an adult that would like to appoint somebody to be able to make decisions on their behalf. So the powers of attorney, whenever I use that word most generally, I'm talking about really 4 documents. Financial, so the power to handle finances and to make financial decisions. Healthcare, that's your general healthcare decision-making power. If any time a person is not able to make their own healthcare decisions, a healthcare power of attorney is the person that would step into their shoes for that situation. Living will allows you to put on paper what treatment you would or would not want in a specifically end-of-life planning scenario. Then there's also a mental health power of attorney, which allows you to appoint a person to be able to make decisions concerning treatment specifically for mental health considerations, such as place of treatment and the ability to consent to maybe some trial studies or experimental medications that sound kind of scary, but note that experimental medication is a very large umbrella, and that covers anything from the idea to the moment of approval. So there's a lot that could be covered there. And all of these together really work to make sure that no matter what life throws at you, you can have a person to be able to make decisions for you without having to go through all of the time and expense and loss of rights that come with a guardianship. Then, of course, a last will and testament, that's more for larger estate planning. So for those of you that are parents or caregivers for a person with a disability, this is very important to make sure that you can put your wishes in writing, so that when you're no longer here, you can know that your wishes will be carried out. So let's dive into that a little bit more, because this is one that I get quite a bit. So I want to start by talking about powers of attorney versus guardianship, because I'll get calls or people schedule a consultation and say, well, they have a child with a disability, and they know that when they turn 18, something needs to happen. And they may have been told or just kind of assumed that they need a guardianship. Well, that's not the preferred method to do it. And there's a lot of reasons why. But the power of attorney, again, a written document where you authorize another person to be able to act on your behalf. The standard for this, now I don't think I have a slide for this, but there's also supportive decision-making documents that are becoming more and more popular. So I'll touch on that for a second. The biggest difference between a power of attorney and a supportive decision-making document is whether or not the person has the authority to make a decision. So a power of attorney does have the authority to make a decision on your behalf. Now, that does not take the power away from the person with a disability. They can still make their own decisions, but that power is shared with somebody else. So if that person is not available, or take it into the financial point of view, the power of attorney would be able to talk to the bank, sign checks, and manage things on their behalf. And likewise with a medical provider, be able to talk to the doctor, get medical information, and if needed, make a decision. To sign a power of attorney, the person signing it must have capacity to understand what they're signing. Now, Pennsylvania prefers this over a guardianship because guardianships are a very restrictive measure. So guardianships have the same end goal. So the person that's appointed as guardian for a person with a disability has the sole authority to make decisions on their behalf. So there's a significant degree of loss of rights that come with a guardianship appointment. A power of attorney, again, you share it. So there's a big difference there. And Pennsylvania prefers a power of attorney because of the loss of liberty that comes with the guardianship. So that capacity, that word is used there. That's not a very high bar. So you don't have to be able to fully read all the legal jargon in there and fully understand it. But most generally, it's as long as the person that's signing the document is able to understand what I mean generally by, for example, financial decision-making or healthcare decisions, and be able to reasonably identify who they would want to be able to have that power. And as long as you can pass that bar, there's a lot of ways, even with physical disabilities, if a person cannot physically sign a document, but they have the mental capacity to understand it, there's still ways that it can be done, either through somebody else or by making a mark like an X or something like that. So as long as the mental capacity is there, this is most likely going to be an option. So I mentioned earlier that guardianship is a court process. So a court has to get involved to appoint a person to make financial and or healthcare decisions for a person. They have to have evidence that the person is incapable of making his or her own decisions, which has to be testified from a medical provider. But again, there's a loss of rights that come with this. And so why is this important? Because again, I mentioned earlier that when a person turns 18, they are presumed to be able to act on their own in their own capacity, and they're presumed to be an independent adult. There's a common misconception that a parent has that power because, of course, up until age 18, that was the case. And you were able to make any decisions on behalf of your minor child. But again, that presumption is there. So as soon as a person turns 18, it's presumed that they are an independent adult, which is a good thing for most people. But parents are sometimes surprised if they're not able to make a decision for their adult child. So the problem with guardianships there is that, and they're not all bad. There are times where guardianships are necessary if a person is totally incapacitated. But guardianships compared to powers of attorney are much more time consuming because, again, we're dealing with courts here. So usually whenever I have to file a guardianship petition, I file the petition and then a hearing is going to be scheduled in front of a court maybe 3 months down the road. And then, of course, it's also in addition to the time consideration, it is a court proceeding. And so there's attorneys involved, which in the more time that it takes there, the more costs that are involved. And it's intrusive because now the guardians are having to file annual reports of your finances, your healthcare status, and all of this is filed with the courts along with the loss of rights. But thankfully, Pennsylvania law presumes that guardianship is not necessary. So if the courts are doing their job correctly, then a person filing for guardianship over another person has the burden to prove that that person is totally incapacitated and completely unable to make their own decisions. And then only at that point would the court go on to the next mode of analysis, which would be who should be that person's guardian. But that first step should be covered. And now, unfortunately, on the ground, there are some problems with this, and there is not as much attention put on these hearings as there should be. But if things are being done right, the court starts by assuming that it's not going to be necessary.
So sorry, can I just ask one question, Landon, while we're on this piece?
Yes.
So when the incompetency hearing, obviously the burden of proof is on the person petitioning for guardianship, it's not taken into consideration necessarily the person's IQ, correct?
Correct. It's not IQ. It's the ability to effectively make decisions, and especially on the healthcare side, the ability to give informed consent to a medical procedure is a good standard to use. But it does have to be the person's capacity does need to be shown under a medical testimony of some sort.
And it's a very high standard, right? So even if you've got a neurodevelopmental saying, oh, this person, this young adult cannot make decisions on their own, doesn't necessarily mean that that's it. The guardianship is awarded.
Exactly. Well, that's the way it should work. So if you read the law, it is a fairly high bar, and there's also a limited guardianship option. So Pennsylvania law allows for a more limited, which gets into an analysis of more specifically what this person is and is able to do. So that way, instead of a plenary guardianship, which is a finding of total incapacity and complete loss of rights, and a person needs to make all decisions on behalf of the other person, there is a limited option where if, for example, a person is able to make all of their own decisions, but somebody else should manage their finances, you can really tailor it. But yes, it should be a high bar, and in all honesty, should be more rare than it is. Did that answer your question?
It did. Thank you, Landon.
Absolutely. And so the process there is that we have to have proof of incapacity by a physician. And again, incapacity there is, and I don't have the exact definition in front of me, but essentially to find full incapacity, a doctor has to be willing to testify that this person is incapable of making decisions in any way. Because again, if you're found fully incapacitated, then you no longer have the ability to make rights on your own behalf. And so when I'm talking to people about this, I say that it's almost like invalidating your signature. An incapacitated person cannot sign a legal document. It's not a legally valid document at that point. So it's a very high bar, and it should be taken very seriously. But in order to start the process, you have to have the physician's testimony lined up. The person that's alleged to be incapacitated, the person that would be under the guardianship, is entitled to personal service. So a person, once it's filed, a person should be physically giving them a copy of the petition and explaining what it means, and explaining that there is a court date on so-and-so date, and they have a right to show up. Technically, if that does not happen, then you cannot move forward with the hearing. And then eventually down the line, you'll have a hearing in front of the judge, which the alleged incapacitated person has an absolute right to attend. And in most counties, this varies county by county, but a lot of them will appoint an attorney to represent the alleged incapacitated person to make sure that their rights are heard by the judge before a decision is made. So, and I'm not going to talk about wills too much, but again, they're important here, and especially for parents, because again, you put in writing what you want to happen to your stuff when you pass away, and your executor who would administer all of that for you. Anybody with any assets needs to have a will. They're quite important for estate planning. But speaking of wills, and that's mainly the main reason that was there, was just to kind of transition into another question that I get quite a bit, which is how is it what is the best method to leave money or an inheritance to a person with a disability? Because as we're going to talk about later, several of the benefits that are available to persons with disabilities they're means tested, meaning that there's a maximum amount of assets that you're allowed to have in your name. And so there's several ways that property can transfer when a person dies. And you need to be aware of this, because just because you name something in your will, and I see all too often that people have a child removed from their will, and I'll ask why, why are you disinheriting this child? And they'll say, well, they have a disability and I know they don't need to have things in their name. Well, that's a good thing to know, but there's a lot of ways around that. But then in addition to your will, there are properties that pass outside of your will. So, for example, life insurance and retirement plans, you have beneficiaries named on that. So regardless of what your will says, those assets are going to go according to what that account says. And so if you set up a trust or remove a person from your will because you don't want to leave them money that would jeopardize their benefits, but they're named as a beneficiary in your life insurance, then they're getting those life insurance proceeds. And your will has no say in the matter. So, a comprehensive knowledge of how your entire estate would be distributed is very important. But same thing with if a person were to win money or get a personal injury settlement or receive an inheritance. So if the person were to receive a certain sum of money, and it depends on what particular benefits they're receiving, that person's public benefits might be in jeopardy. Now, of course, if we're talking huge sums of money, if somebody's, has a rich relative that's going to give them millions of dollars, then that might be lifetime money. But let's say a well-intentioned relative leaves $10,000 to somebody. That's a good amount of money, and that can last for a little while, but that's not lifetime money. But it could be enough to kick somebody off their benefits. So that's something that you need to be aware about. And income is usually not. Income's also looked at depending on the benefit. And if a person is married, then that person's spouse's income could also come into play. So knowing what resources are available and what resources might become available in the future is very important for a comprehensive special needs plan. So options to deal with this. So, and I'm going to go over these in a little bit more detail, but there's special needs trust or supplemental needs trust. You might see that written both ways. It means the same thing. I personally prefer supplemental needs trust. It's the exact same type of trust, but it uses softer language, because I've spoken with several people that seem insulted by the term special needs trust because of stigma. And I think supplemental is a little bit more accurate for what it is, because the purpose is to supplement any benefits that exist. And then you don't necessarily have to fit any other criteria other than being disabled as under the definition that Social Security would use. There's also ABLE accounts. I don't remember the exact year. It's been in the last 3 or 4 years, Pennsylvania passed the ABLE account law. So this is also another method that works to have assets available for a person, but not counted as their assets for purposes of their benefits. And for smaller sums of money, if you see, for example, SSI, if that person's account gets up to, say, $2,100 and they need it to be below $2,000, then you've got a month to spend that down. So, go shopping, find something to spend $100 on. That's the easiest way. But of course, for larger amounts of money, that well-intentioned relative that leaves you $10,000, you're not going to want to spend that kind of money in a month. So let's look at some of these other options here. All right, so a special needs trust, I really want to update this to make it a supplemental needs trust. But again, the purpose is to supplement and not replace whatever benefits a person's already receiving. And so the idea, as with any trust, is money could either through an inheritance or gift be put into this trust and be managed by a trustee who would manage all the money in the trust and make sure that it's there for the needs of the beneficiary, which is the person with a disability. But under such rules so that it's not the person who's the beneficiary does not have direct control over how it's used and it couldn't be used in such a way that would replace benefits, because the goal would be to have money there if it's needed, but still to retain any benefits there that they might be eligible for. Able accounts are really interesting too, and they work they work for a lot of different scenarios as well. So the standard there is that they are for people who are determined to be disabled prior to age 26. And anyone can create it for them. So you could create it for a loved one, or the person with a disability can create it for themselves. But every beneficiary, so a person with a disability, can only have one account. So regardless of who it's created by, there can only be one account per person. And then there might also be, there's a loosely defined payback provision, meaning that if a person with an ABLE account needs nursing home care later in life, under certain circumstances, money in the ABLE account might be eligible to pay back the state after that person passes away. So that's one thing to be aware about with an ABLE account. But for younger folks, it's a really good option. And there's some benefits over trusts that make them desirable to a lot. But these differences are worth exploring, because not every plan is the same, and what works for one might not work for another. And so some of the restrictions on this account is that you can only put $16,000 per year into the account. And this is from all sources. So, if somebody got a larger inheritance, say more than $16,000, then ABLE account's not going to be able to spend that down quickly. And if you are getting regular amounts of money and adding it to the account to make sure that you're able to get that money out of your account every month, you want to make sure that you're not accumulating more than $16,000 per year from all sources. Also, specifically for SSI, an ABLE account can only have a maximum of $100,000 total. Without SSI, we've got over $500,000 that can be in there, but SSI is one of the more strict means tested programs, and so you've got that $100,000 limit there. The general confines of distributions from this account are for quote unquote disability related expenses, which is interpreted pretty broadly. So realistically, as long as the money's being used for the named beneficiary and there's some reasonable relationship between that distribution and a need of that person, it's probably going to be admissible. And unlike a trust, an ABLE account can pay housing expenses for a person on SSI without getting a reduction for in-kind support from that would normally come with free housing. So that's one big benefit is for a person on SSI, is that you can use an ABLE account for distributions that would not be permissible under a trust. Now, special needs trusts don't have those limits. So any of those limits, if you were to get a larger sum of money, and one of the common places where you see a big need for a special needs trust is if somebody gets an insurance settlement. So if somebody becomes disabled as a result of a automobile accident, for example, and gets a very large settlement from that, there is no limit on the trust. So the trust can protect a much larger amount of money, and you don't have to worry about the amount of assets contributed into there on an annual or overall basis. Now, there's fees associated. So when making a decision between one or the other, you just have to look at each case's circumstances, because the fees for managing ABLE accounts are relatively low. And trust, it all depends on your trustee. So there are a lot of organizations or institutions that can serve as trustees. So you might see banks, nonprofits serving as trustee to manage all of that money. And there's a fee associated with that. And then, of course, be aware of those limits on contributions. So contributions to an ABLE account must be in cash. You can't move stock, for example, into an ABLE account. A trust could be used by any type of asset. So you can put real estate, you can put stocks, really anything, any assets that you've got can be moved into a trust. So trusts have larger flexibility, but ABLE accounts they're much less costly upfront and in overall management, and they've got a little bit more liberal rules in terms of how it can be used. Again, And you're not confined to one, so you could have both. So without knowing anyone's individual circumstances, I can't tell you which one is better, but it's good to know that both are out there. And then I mentioned Medicaid payback. So if a person needs long-term care, Medicaid's paying for it. They're going to bill that person's estate when they pass away. So you want to make sure that if that's a concern, especially if we've got a big sum of money, that that's part of the analysis. And I've had a lot of this quite a bit. But if you do have both, one thing I didn't talk about yet is that a supplemental needs trust can pay into an ABLE account. And so if you've got an ABLE account that's set up, this is a situation where if a trust can pay into an ABLE account and an ABLE account can pay housing expenses, then that's permissible. Don't ask me how. I don't make the laws. I just am supposed to know them, but that's a good planning option there that could come with having both. But all right, and so I've already used a couple of different acronyms. So let's look at the two most common ones that people get mixed up. And so I'm going to start talking about a little bit of different benefits that might be available. The two most common that people get confused about when I ask, what benefits does a person receive? They'll say, well, it's through Social Security. I don't know. Well, the unfortunate fact here is that they use very similar acronyms, but there's SSDI, which is disability. And a person that's getting disability is qualified for Medicare. And it's based on a person's work record. And I'll get into this, but it could be paid if that person that's disabled has their own work record that they can work on, then they could be paid through that. Or a person with a parent with a deceased or retired parent can draw SSDI from that parent's work record as well. SSI, on the other hand, is a needs-based program. So the disability insurance, they're not going to be looking at your assets to make sure you stay under a certain level. SSI, on the other hand, they will. And instead of Medicare, it triggers Medicaid health insurance. And then I've got my maximum payments there. Social, as you can see, there's a big difference in the maximum payment. So disability can max out at over $3,000 a month, whereas SSI would be $841 max, or $1,261 for a couple if both people are eligible for it. But you got to watch out for those asset limits because, again, in most cases, a person's total assets need to be below $2,000 to stay with SSI. So it's important to know if you're a caregiver or working with a loved one with a disability, if they're receiving benefits, it's important to know which one. And then they're only one letter off, but again, SSDI is disability. SSI is the supplemental security income. All right. And so SSI is a very common one and it's one of the first things that people start looking at when a person with a disability turns 18. Because as a child, they might get some Social Security benefits. And at 18, they might lose those unless they're still enrolled in school, because in most cases, you can stay in school up to 21. Or if they're found, but if they're found disabled under the adult criteria, which is using Social Security definitions, then they might be able to continue that Social Security under the SSI program. And then if you were to do an application and be denied, you can appeal any denial within 10 days and continue benefits. So if they say for whatever reason, you're losing your benefits, you can appeal within 10 days and your benefits will continue during the period of that appeal, because that's not a quick process. And if that needs to happen, attorney's fees are limited by the Social Security Administration. So don't think just because you get a letter from Social Security saying you're being kicked off benefits that there's no recourse there. All right. And there's another one here that's less known, but it's a really interesting way to get medical insurance for a person that is able to work. So, of course, in both of those, I mentioned that if you have SSDI disability, you can get Medicare. If you have SSI, you can get Medicaid. But what about a person that doesn't really qualify for either of those, but is not able to work a full-time job to be able to be fully self-sufficient enough to pay for their own health insurance out of pocket? There's medical assistance for workers with disability, or MALD, which with my accent is pretty easy to pronounce. So here's a little bit of qualifications for that. Got to be at least 16, under 65, and employed and getting paid. That's a very broad scale. As long as you're doing some level of work and getting paid for it. This could be minimal hours, but as long as it's something, then you would fit this requirement here. That this person does have to be disabled according to Social Security's definition. And you can't get this if you're getting SSI. So it's either SSI or medical assistance, or MALD. But again, if you're getting SSI, you're qualified for Medicaid. So your medical insurance would be taken care of. And they don't use the regular income standards, but your countable income, it needs to be below 250% of the federal poverty income guidelines. That's a sliding scale year to year, but I've got your 2022 numbers in there. So total income that they would count below $2,831.25 for a single person, or $3,814.58 for two married people. And then countable resources. So again, this is your overall assets below $10,000. And I mentioned, so not all earned income is counted because they disregard some of it. And so it's possible to earn other incomes and still be eligible for this. And I've got a website there that kind of parses this out. So instead of making a slide that's a little bit too convoluted here, this is one of those resources that you can certainly get afterwards if you're interested. But there are some exceptions. So it's not just all the income that would go on your annual tax return. It's looking at specific types of earned income. And also pertinent to that $10,000 asset limit, there is no look back. So if you're not far over that limit, you can gift money and still qualify for this program. Unlike Medicaid, it does have a premium, but this is where your income becomes very important. So I said earlier that you can qualify for this even working low amounts of hours because they cap your premium at 5% of your income. Your countable income. So whatever that number is, you're capped at 5%. So if a person's only making $100 a week, they're not going to be, paying a huge percentage that would make it prohibitive. So that's a really good way to make the premium a sliding scale. So that way, theoretically, it should work for anyone who qualifies. All right, going back to SSDI and SSI. One of the questions that I get there is, how are they treated in terms of rent? Because if any of you are familiar with SSI or are working with a loved one who receives SSI, you've hopefully been advised that if that person is receiving free housing or food, then you get a reduction in the amount of benefits that they receive. So this is true for SSI. But now SSDI, that disability insurance, is not means tested at all. So if they're living rent-free in your house, that's not a problem. SSI, on the other hand, you don't want to have somebody living rent-free. So even if it's your child, for example, fast forward a little bit, they're already 18, they're receiving income. They're receiving SSI income, but they're still living with you. If they're not paying anything towards housing, then they could get a reduction in their benefits. So the way around this, and it always sounds, I get a puzzled look from parents when I recommend this, but you can charge that person rent. Now, I know it sounds weird to think that you would be charging your child rent to live in your house, but the idea there is that they're paying for their own housing, and it needs to be a reasonable rent. So you're not going to take all of their income, but based on their $800 a month income, charging something reasonable. So that way they're paying to stay there. And the idea there is that if you're charging rent, yes, that money's leaving their account and they don't have access to it anymore, but it's staying in the household, because if they're living there, they're still using utilities and contributing to bills, and there's taxes to pay, and there's groceries to buy and things like that. So it keeps it in the household, and it prevents you from getting that 1/3 reduction in the benefits. So you can still maximize the benefits and keep that money in the house. And remember, assets need to be below $2,000 anyway. So if this person has no expenses whatsoever, then their assets, it's very possible that their assets would quickly accumulate above the 2,000. So paying rent is a way to keep that those total assets below 2,000 and keep the maximum benefits that they're able to use. Because of course, if alternate placements were to be needed outside of the home, you're going to need the maximum income available to you to be able to pay whatever contribution they need there. And do note though that able accounts can pay rent without this deduction. So that's a good thing to note there. All right. And I'm going to leave quite a bit of time for questions here, but just to give you a little bit more, we got a little bit more of background about our firm here. So we've got certified Medicaid planners, attorneys, and support staff that are really knowledgeable in this area of law, and everything is individualized. So we have our firm is experienced in all levels of estate planning, and we do not have a blind spot for any special needs planning. So any plans that we make, if we know that a person has a disability, that's going to be taken into account with knowledge of all this that would be available to them. And so, I told her that I would try to wrap up my speaking at around 7:45. So, how often do you see a lawyer staying on time there? So I'm going to
We've got lots of lawyer jokes, Landon, we could bring up right now. Billable hours.
No, I'm doing this for fun. That's
I know. Landon, we've been very lucky that Landon is doing this, just to get information to parents, because, there's an understanding of how important it is of getting this information out. I do have one question though about this rent thing. So on Social Security, they class it as room and board, not rent.
Yes.
If you're living in, so there is a difference, right? I mean, you wouldn't want a parent to put down that they're charging rent, but versus room and board. Is that how that would work?
And it doesn't have to be necessarily that formal. So as long as they're paying room and board, I mean, rent would be a form of that. So if they're paying regular monthly payments towards a parent or whoever they're living with, that should satisfy that qualification. As long as they're not paying nothing, as long as it's reasonable. We certainly don't want it to be the entire $800 a month, but something reasonable that they're paying and contributing towards the household.
Now, somebody is one of the questions that I had personally was so that if somebody was receiving as a rep payee, because when you're receiving SSI, you establish a rep payee, or you can do it as self-directed, correct, and use an agency, or you could just do it yourself.
Correct.
With a rep payee though, can they just take whatever they want out of it for clothing or anything? There's an established amount only that they can take as a percentage, correct?
Correct. I mean, the rep payee should not be commingling the person's money with their own. So there should be a separate account for this, and they should only be using that money for that person's needs. Or you use clothing as an example. So if that person needed clothing, then you can certainly use the rep payee account to buy it. Or if we're charging room and board, then they could be paid out of that account. But one thing that people do that's not correct is just get the SSI check and throw it in the parent's account, because then you're commingling it, and they should be keeping separate accounting of all of it. But
and because they do have to provide accounting.
Correct. Yep.
Of where that money got spent, correct?
Correct. Yep. You are receiving a benefit from the government, and they certainly have a role in making sure that you're using that money properly, because, and hopefully people don't see it very often, but there is misuse where, a rep payee might just think that this is their paycheck, and that's simply not the case.
Yeah, because I do know that there are cases where individuals haven't had access to any of their money.
Yep, and that's unfortunate, and that's not the right way to do it. The rep payee is a fiduciary, so Their job is to hold that money solely for the benefit of the person that's receiving the SSI.
Yeah. We have some questions from the audience, so I'm going to bring up one so you'll see it on the screen.
And I'm gonna stop sharing my screen here so I can join the room back. But just so you
Oh,
know, I mentioned that at the end there's a lot of resources. So I'm going to blow through these pretty quickly. But all of these will be available to you after the presentation. And but there's our website. We've got a YouTube channel, podcast. There's Social Security, Medicare. More information about MAUD because again, I hit that one pretty quick. ABLE accounts. That's where you would go to set one of those up. There's Office of Vocational Rehabilitation, Bureau of Blind and Visual Services, PA Health Law Project, PA Link Helpline. Any of these things, like I said, are very great resources that are out there that we can send these out to you. I'm not going to go through every single one of them, but just, and then there we are. We've got those 4 offices: Williamsport, State College, Wyalusing, and Wysox. So I'm going to go ahead and stop sharing though, so I can kind of join everybody back in the room here.
And so if anybody wants any supplemental information, as I said at the start, that you can get a 1-hour consult for free through this law firm. There is a MailChimp survey at the top where you can put in your details and the things that you're looking for, and they will be in contact with you. They're very responsive. So, but we have a question from Maggie up on the screen. So Maggie, Thanks for joining us tonight. She has asked, whose income does SSI look at if I would have guardianship of my son after 18?
That's a really good question. So after a person turns 18, they're qualifying or they're applying for SSI on their own assets and income. So it would be, in your example there, your son. So you're looking at your son's numbers and they're not going to be looking at yours. Even if you are guardian, they're not going to be looking at yours because it's your son that's qualifying.
Yep, that's great. We have some, so we received quite a few questions through the email. That one of them was, what are an adult guardian's duties? Okay.
And generally, now there's, and I should have parsed this out a little bit more because I'm certainly not down in guardianships because guardianships are good. When they're needed, they're necessary. There's 2 types. There's guardianship of the person, meaning that you're in charge of making healthcare decisions. And there's guardian of the estate, which is the financial side. Now, a lot of times you'll see somebody do both, but it doesn't have to be the same person. But generally, the most general answer to that is that the guardian has a fiduciary responsibility to act in the best interest of the incapacitated person. So whether that's the guardian of the estate making financial decisions, they have a duty to manage that money in a way that's going to be in the best interest of that person. Likewise, on the healthcare side, they're the point of contact for all medical providers to make decisions in that person's best interest. There should never be a situation where a guardian is making decisions of what's best for them. It's always the incapacitated person that is that is benefiting from this.
I'm just putting in, Anissa's asked to do this. I'm just going to add this in here. Anissa, there is a survey so that you can just fill that in and then they can get in contact with you directly. So I'm going to add that to the chat for Anissa. I apologize if I'm mispronouncing names. I'm terrible at that. Just ask Landon from the beginning of the presentation. So we'll go through some of the other ones. Jennifer, do you want to read out the questions that you've got from the email?
Yep. So if as a parent you are interested in getting supported decision-making for your child, would you recommend also getting a POA in addition to the supported decision-making due to the fact supported decision-making is not yet acknowledged by the law?
Right. So that last point is a good distinction to make. So Pennsylvania does not have a statute on supported decision-making yet, but the main difference between the two is the ability to actually make decisions. So my understanding in other states where this is becoming more common is supportive decision making allows you to put people in place that would be involved in a decision making, but the person who's signing it is ultimately making the decision, and they're the ones with the sole authority to do it. They're just putting people down that are able to be involved. On the other hand, a power of attorney can make a decision. And so if a decision maker is needed, a power of attorney would be the way to go. But if the person that's signing it wants to retain sole agency to make a final decision, but wants their doctors to be able to talk to other people and have other people that are involved, then that's the least. So a supported decision making document is the least restrictive because it allows you to retain all agency, whereas a power of attorney shares that agency with another person that can also make decision. And I guess guardianship would be the most restrictive, where it takes away the agency of the person to be able to make decisions and appoints a sole decision maker on your behalf. So I guess it's 3 levels. You could have both. For example, if you've got a power of attorney where you've named your decision maker, but you want other people to be able to be involved in the decision, that's where both would come into play. So I don't think there's a wrong way to do that. They just fulfill different objectives.
Yeah, you wouldn't have a supported decision-making agreement if you're going after guardianship.
Guardian. Yeah, if you go to guardianships, then that's assuming that the person that's under the guardianship has no ability to make decisions, so they don't need they're not going to be.
Don't need any other agreements. And somebody whose guardianship has been taken away from them doesn't get a chance to vote either, do they?
I'm sorry, what was that question?
When for somebody who's been found incapacitated and has guardianship or conservatorship removed from themselves, and it's in the place of somebody else, they don't get to vote, correct?
Yeah, they're not allowed to vote, and there's a lot of legal rights that they don't have. So they can't vote, they can't sign contracts, they can't. There's actually a form that you have to fill out that shows that they would fail a background check if they tried to buy a firearm. Those types of things that they're not going to be able to do.
Yeah, Eileen Walsh has. Do you have to disclose a third-party special needs trust when applying for SSI and MA?
Great question, and that brings up a good point that I kind of missed there as I was going through things. But third-party special needs trust. So for those of you that saw that and might be wondering there, a third-party special needs trust means that it was set up by someone else, so not the beneficiary, and it can only be funded using other people's money. So this is what you would use if you're setting up something to leave an inheritance for somebody. But the person that's the beneficiary could not use this type of trust to lower their own assets. But to that specific question, you do need to disclose the trust, because whether it's MA or SSI, the Department of Human Services or the Social Security Administration has to approve the trust. And as long as it meets all of their qualifications, they'll approve it, which will make it a non-available resource. But if there's something wrong with the trust, I've had a situation, thankfully I've only had to do this once, where I had to go through court to fix a trust in order to help try to preserve somebody's benefits. So they don't necessarily have to know everything that's in there, and they might ask, because a lot of times, especially with first party trust, which is the opposite side. So if I'm trying to get qualified for SSI and I just got, $100,000 in a settlement from a automobile accident, then I could set up a first party special needs trust and put my money in there to get it below. Either way, it needs to be approved by the granting government agency.
Okay. That's a great answer to that question. Next one, I think we're going to go with is how. Where is it? We've already gone over that supported decision making. Quick question for you. In regards to ballpark costs for like power of attorney or going for guardianship, what are parents looking at in that sense? Obviously, you can't give a price,
right?
But we have sort of an average of what that sort of costs are.
Yeah, and that all depends on the quality or breadth of what's covered in the power of attorney and where you go. So that's kind of all over the place. Now there are legal services available through in the Williamsport area at least, and the northern tier. North Penn Legal Services that if you if you qualify in terms of income and assets, then you can get pro bono legal services. But the easiest way to, I think, generalize it is that powers of attorney are usually for the full set are usually measured in the hundreds, whereas guardianships get into the thousands. So, which, I mean, if power of attorney is on if a person is able to sign a power of attorney, that's always the option over a guardianship. I only want to do guardianships if a person is if it's very clear that this person is unable to make decisions.
Yeah, and I did put up, so I went on to, where was that? I went on to our lovely Laura Cornell website and put up the definition of incapacity.
Great.
So it's a lack of physical or mental abilities that results in a person's inability to manage his or her own personal care, property, or finances. But it goes into a little bit more than that. It's also a lack of ability to understand one's actions when making a will or any other legal document. So that would be contracts, car loans, rental agreements, all of that sort of stuff. I'm presuming would be covered under that legal document piece. Would that be the correct assumption, or am I being the mean?
I'm sorry, which one was that?
So it says that the second part to the incapacity
Two.
is a lack of ability to understand one's actions when making a will or other legal document.
Exactly. That's getting into the ability to sign a document or understand it enough to sign it yourself. Because again, if you can do that, then you should be signing a power of attorney as opposed to going to guardianship.
I think we've got to remember too that, even if somebody has a cognitive disability, that they're, what we call mildly cognitively impaired, 70 IQ or below, doesn't mean that they couldn't have the supported decision making. We have a lot of individuals now who are living on their own with the support from their waivers to have caregivers come in and help them out, using agencies such as Advocacy Alliance to do their rep payees, so they pay their bills and then the individual gets the rest of their money for the month and things like that. I know in PA particularly that, like you said, guardianship should be of such a high a high standard to meet, so that we don't take away the decision making of individuals. And that was the reason why institutions have been started to be closed down, like Penhurst and things like that, because we're going towards this model of more of competency and supported than, just removing the ability of individuals to make their own decisions. How does your law firm fall into that piece?
In terms of where we come in
where your stand is, in regards to, obviously you've said that your personal preference is not the guardianship piece, but is the overall feeling of the law firm that you want to keep the rights of that individual?
Absolutely. So our approach, if we're engaging somebody for special needs planning, it's all, anytime, because guardianships are such a high bar, there's a loss of rights and a loss of agency there. And so, the goal of any sort of planning, especially long-term, because I'm working with a lot of people's parents that might be aging themselves, and they're looking at, okay, this person's lived with me their entire life. What happens when I die?
Yeah, that's a great question, that we have that as a question. How would that best be responded to if somebody came and asked you that?
Yep. And that's, normally there's a lot of community resources that can help a person live as independently as possible. Powers of attorney, if they're able to sign them, are first step to making sure that they have, maybe their parents might be the first power of attorney, but you've got a succession there. So who takes over when that parent passes away? Maybe a sibling, maybe a trusted, individual. But the approach that we all take anytime we're doing this type of planning is to retain as much agency as the person can have. So you make a great point that diminished capacity or low IQ does not mean incapacitated. And so that's a question of what, are this person, to what extent is this person able to understand and make their own decisions without and without being exploited. And I always try to gauge environments to make sure that the person is not going to be exploited, because powers of attorney do have large consequences if in the wrong hands, like any power. But generally, I never have a guardianship conversation with somebody without talking about powers of attorney, and I don't file guardianship petitions without meeting that person, because I want to make, as the attorney on the case, I want to be able to make the call myself as to whether or not this person could sign a power of attorney, because that's more of a legal standard. And honestly, if it's if I'm close, I like to err on the side of the power of attorney. And if that power of attorney is not respected because a doctor disagrees with me, then I know I need to go for the guardianship. But at least we try the least restrictive option first.
Mm-hmm. Maggie's asked another question. She said, can I start the guardianship process before 18 years old? Child is 17 and a half.
That's another good one. And so I've had success doing this. I wouldn't go much younger than that, but 17 and a half is a good age. Because like I said, once you file a guardianship application, it's going to be a matter of months before you're done with that process. Mm-hmm. So I've worked with people that 17 and a half, I'll go ahead and get my petition together. And there are certain rules I need to do for courts for minors, but I'll file it as if they're a minor and say, when I file it, I'll ask the court, just to make sure you schedule the hearing after 18th birthday. So that way we can already have the process started. And then as soon as the hearing happens, that person will be 18 and be eligible for it.
Yeah, because I do know, like, sorry.
I was going to say you can start it, but I wouldn't do a 16-year-old, for example. I mean, if that's a little too early, but 17 and a half would be pretty good.
Yeah. So I know with SSI, they caution not to apply for adult SSI until they've turned 18, because if it gets pushed through, it could be denied because of income.
Right. Because before 18, you might be looking at the parent's income.
Exactly. And if you file without that parent income on there, then you're likely to get it rejected straight away.
Exactly. And most likely a person that just turned 18 and has a disability is not going to have significant assets. But the parents, it's so SSI, that's a good distinction. SSI, you should wait till 18, but guardianship, you can get the process started earlier because it is a process. It'll depending on your county, again, depending on how populated your county is. But in most counties I work in, I usually tell people to expect 2 or 3 months from the time I get the application in, the petition, but I've still got to get my doctor's testimony and all that stuff lined up before I even file the petition. So it can be a process.
So we know what happened with Britney Spears. Everybody heard about her conservatorship and how restricted that was for her. I mean, she wasn't even allowed to make a decision on whether she had another baby or got married, even getting engaged. She wasn't allowed to have, any expenditure without prior approval. Is that the same for everybody that gets guardianship taken away? Because I think that can give somebody an idea of what happens to that individual.
Yeah, and actually that was a really good case, and I hate that happened to her, but it was a good example for nationwide understanding of what's going on there. Now, this is, and I don't know how broad of an audience we have, but just to make this a distinction in some terms, I kept using guardianship, which is the Pennsylvania term for it. She was in California, and that was a conservatorship, but we're talking about the same thing. I certainly haven't seen her orders. I don't know the breadth of it, but what it sounds like, if she had no power to make decisions and had to go through her guardian to make basic things, she may have been under a plenary conservatorship, meaning that the conservator was given full power to make all decisions. That's not all of them, because they can be limited. So I saw a limited conservatorship. I was helping a family transfer one from California to Pennsylvania. And I certainly can't speak about California law, but it was a limited conservatorship. So the person did not get declared incapacitated, but the court gave their mother the power to do contracts, sign checks, and to make marriage decisions. So it was a very much more limited situation there. So they can look different, but
yeah, and I know that there can be different things added in or taken out, obviously, but still, again, very restrictive, the most
yes,
restrictive.
and yep, and plenary, unfortunately, is the easiest one to plead. So in your petition, you're going to see a lot of plenary ones, and it's just going the easy route. If a person needs a plenary guardianship, there are times where you do, and I see that with a lot of my much older clients that have far progressed Alzheimer's or dementia, where somebody really needs to take over. But limited guardianships are preferred, but unfortunately, you don't see them as much as you should.
Yeah. Anissa has said, are there specific adaptive functioning tests you suggest we ask the school district to perform to have a higher probability of getting SSDI approved initially? From your presentation, it would be SSI, not SSDI, correct? For a student
right. Well, now with disability, there is a disability qualification. They have to meet the Social Security definition of disabled. So there would be some sort of test of functioning test there. Now, in terms of the specific types, unfortunately, I'm not able to give too much of a detail on that question.
I would actually advise having a neurodevelopmental doing the adaptive functioning tests. What schools have can sometimes be limited in their scope, and you're more likely to get, other tests done. But you would be looking at things like the adaptive living, looking at what they're able to do and can't do in regards to the independent living pieces of it for the adaptive functioning. If there's a physical disability, obviously you want to have functioning and physical limitation pieces actually documented through their specialists, whether that be an orthopedic, whether that is a geneticist, to have those things within the medical record. The school is just showing the eligibility pieces. So even if you have a specific eligibility, say for autism, and they do a comprehensive evaluation, it may still not show the full scope of the ability or non-ability of that particular individual. So I always recommend parents, to look at, having that shore up with those medical professionals, because it's not just the school district. You do have to have something, though, for Social Security that has to be done within the last 3 years from the school, like to add to your paperwork. You want current evaluations. And then we've got from Kerry Freeman. She said, to qualify for SSDI, wouldn't they have been required to have been paid taxes and have a percentage of quarters worked, have a number of quarters worked?
If they're going to qualify on their own record, then there would be some personal qualifications to having paid into the Social Security system. But that's only one way to qualify. If they have a deceased or retired parent, then they are able to actually use the taxes paid and quarters worked for the parent's record to pull from that. But if the parent's still of working age, then the parent would need to be disabled themselves. So if the parent's getting SSDI, then they could probably pull from that. Or if they're retired.
Can they get both? Can an individual get both if they have a deceased parent and receive SSI at the same time? Or is it one or the other?
Oh, you mean qualify on both their own record and their deceased or disabled parent? Yes, they could, but there's a maximum, and it was on the slide. It was over $3,000 a month, but
yeah,
$3,000. They would need to watch out for that maximum.
Yeah. So they'd have to really watch that to make sure that they didn't max out, and then
the Social Security will cap
2,000, right?
Yeah, Social Security will make sure they don't go over that one. So if their parents' work record is such that they're getting $3,300 a month from that, then no, they could not get on their own record. But if you're getting much less than that, then you should be able to mix and match.
Yeah, but then if you've got an ABLE account, if they're working too, then that's going to benefit them to be able to put their max out into that ABLE account or into a special needs trust.
Right, which then again, if they're comfortable on SSDI, they're not going to be looking at their assets, so they wouldn't necessarily need to put extra money into a trust or an able account, unless they're going to need to do SSI or later, looking at specifically long-term care Medicaid.
Right. So if somebody was an SSI and the parents purchased a block of land and put that asset in trust to build a home for their child, and that child pays rent,
Mm-hmm.
that could be theirs in trust, correct? Like it wouldn't.
Yep. As long as the trust qualifies and the trust is approved by the appropriate government agency, then that technically the trust, would be the landlord. So they would need to pay room and board to the trust.
To the trust, right? Yeah.
Yep. Which again, then
And
you're
then the
accumulating
trust can
assets.
manage the property.
Right. They manage the property. Pretty much that money would be going into a pool that's going to be used to pay the taxes on the property and all of that. So it's useful, but they would still need to pay rent, even if the trust.
And it doesn't affect the individual.
Correct. Yeah. As long as the trust is approved, that trust, that the value of that property is not going to affect the person.
Okay, that's fantastic. What we're going to do, we are at almost time. If anybody has any more questions, jump in now because we'll be jumping off. And I just want to remind everybody that there are tagged at the beginning of this, so you'll be able to go back from the recording to complete the MailChimp survey, and I did put it down again below. All of the, what I'm going to do, actually, I'm going to do it right now, is I am going to add a link, create a link for the presentation that Landon just provided us. It's just going to take a minute. It's uploading to the cloud.
Okay. And actually, I just saw one other question pop up, and I think I might need to clarify where I'm at. So, because it's very confusing with my town name. So I live in Jersey Shore, which is nowhere near New Jersey. It's near Williamsport. So we've got Carrie asked how much of PA do we serve? We've got offices in the northern tier in Bradford County, which would cover the surrounding counties there. We're at Williamsport, so around Central, and then also in State College. So that allows us to cover quite a bit of area. I think I've done guardianships.
It's really only just the lower southeast that you don't cover.
Yeah, we certainly don't go into the Philadelphia area or even as far as Lancaster. And then west, I've done guardianships in Huntingdon County, Blair County, and then as far north as I've not done one in Susquehanna, but Tioga. I've done one in Elk County. That's probably as far west as I've gone. But there's several counties that are covered there. If you can picture central Pennsylvania, you can kind of just block off
and a little bit of northeast,
the middle, and then certainly the top with our new offices.
Yeah. So what I've done is I've actually put the link for the presentation into the chat, so people will be able to just click on that and be able to find all the resources and everything that are on the presentation PDF. So we should be good. We're getting, lots of thank yous. We had lots of thumbs up and hearts coming up through the presentation. You were probably just on your presentation screen, so you probably wouldn't have seen it.
Yeah, I just saw my slides. I hope everyone enjoyed it and found it informative. And there's a lot of resources there. If you go to the end of that slide, there's all kinds of links you can go through to get more information. But
and we do appreciate your time because this was really invaluable. We Special Education Advocacy Services will be looking at towards the end of the year of actually putting together a legal and medical in-person forum. It won't be, it's almost like a mini conference, but not really a conference. It's just a few hour thing, and we'll be looking for that. So. Thank you, Maggie. Maggie says, thank you so much for all of your hard work. But it was actually all Landon. The whole lot was Landon. So thank you.
Thank you for setting it up. Without all of you, we wouldn't have been here. So, and thank you, Maggie, for the kind words. It's hopefully it was good for everyone. So we're going to end the broadcast now because there's no further questions coming in. Thank you all for joining us. You can replay this at any time. If you look at the video links on the Facebook page. And thank you very much for joining us. On Friday night, we have Parenting Autism United coming on and having a
talk about the new 501c3 that they've started to provide services for parents with autism, children with autism in Northeast PA. Thank you, Anissa. Go back, watch it. It should be up in about 10-15 minutes. You'll be able to click back on it. Landon, stay where you're at.
All right. Thanks.